Well, good morning, everyone. Welcome back to the second day of the hearing in the appeal between Chubb Insurance Company and Enka. And we'll invite Mr. Dicker to continue with his submissions. Good morning, Mr. Dicker.
Good morning, my lords. My lords, I have a considerable amount to try and cover today. I intend to follow the structure of our written case. A good part of the argument before the Court of Appeal was concerned with the significance and role of the Court of Seat and the curial law. Lord Justice Popperwell dealt with this at some length in his judgment, paragraphs 42 to 46. The first point I want to make is that Chubb largely ignores this aspect of the matter in its written case. The decision of the House of Lords, for example, in the front Coma West Tankers case, isn't cited anywhere in Chubb's written case and wasn't included in its authorities. In our submission, determining the issues in this case requires one to have regard to such matters, and Section B of our written case sets out a series of propositions in this respect. I don't intend to go through them because they're dealt with at length by the Court of Appeal. But in our submission, they emphasize the connection between the arbitration agreement, the Arbitration Act, and the supervisory jurisdiction of the English court. They illustrate what I've been referring to as the gravitational center of the parties' dispute resolution mechanism. I do, however, want to emphasize the point in paragraph 13, the end of section B of our written case, page 331 of the electronic bundle. We say this package of rights and obligations provided by English law is among the reasons why parties choose one seat rather than another. Now, it's sometimes asserted that arbitration agreements are just boilerplate provisions inserted without any real thought. It would be surprising if that were the case. One would generally expect sophisticated commercial parties to give some thought to the appropriate dispute resolution mechanism and location of the seat, particularly, I might say, in a case like the present one. Now, the authorities emphasize that, as one would expect, parties do choose the seat of an arbitration on the basis of what they consider will best serve their interests. And at footnote 14 of our written case, we refer to a number of such statements. Given the amount I have to go through, I'm not proposing to turn references up, but I'm sure your lordships have seen Lord Hoffman in the front Coma case emphasizing for the benefit of the ECJ the importance of the autonomy of the parties and their right to choose the governing law and seat according to what they consider will best serve their interests. And similar comments by Ms. Justice Cook in the Shashua and Sharma case, and by Ms. Justice Cook again in the C and D case. One further reference, just to indicate that this isn't parochial, one can find similar statements in authorities in other jurisdictions. For example, Justice of Appeal Stephen Chong in BNA and BNB. I'll just give your lordships the reference. It's electronic bundle 1257, paragraph 3. He referred to the fact that the party's choice of seat and governing law would be informed by what each party perceives to be the most advantageous or favorable to it. And the empirical evidence supports such statements and confirms what one would otherwise expect.
I'm sorry to interrupt, Mr. Dicker. Did you say 257?
I'm sorry, 1257.
1257. Thank you very much.
There's an article by Lord Mance entitled Arbitration a Law Unto Itself, which he gave, I think, in 2016, which your lordships have starting in the electronic bundles at page 1746. And I'd like to show you a couple of passages from that. The first passage starting at 1747. Your Lordships have that. Under the heading English law, 6 lines down, Lord Mance says, English law does not recognise what Lord Justice Carr once called arbitral procedures floating in the transnational firmament, unconnected with any municipal system of law, and arbitration must therefore be assigned a juridical seat. Then if one drops 4 lines, it says, in English law eyes, the effectiveness and probably attraction of arbitration depends upon the possibility of more or less circumscribed court intervention at potentially critical points, e.g. to determine whether or not an arbitration agreement exists, to assist its implementation if it does, e.g. by appointing, removing or replacing an arbitration, or, save between EU or Lugano states, to injunct proceedings brought in breach of an agreement to arbitrate, to issue interim measures, and to enforce, in some cases, to set aside, any award. And then if your Lordships turn to 1756 in the electronic bundle, under the heading, the sound approach, Lord Mance says, in short, the English view is, in my opinion, a principled one. Decisions of the court of the seat are decisions which the parties must, on the face of it, be taken to have accepted when the seat was chosen, and should, in the ordinary case, be treated as final and binding. He says this is what the Arbitration Act 1996 contemplates in England. More importantly, it is what the New York Convention contemplates, at least as the norm, and he sets out 3 references. And then over the page 1757, he says in the first full paragraph, what the parties must be taken to have contemplated is particularly important because it meets the transnationalists and those who give no particular weight to the seat on their ground. They are the advocates of party autonomy and of giving effect to the parties' agreement to arbitrate. On the face of it, parties who agree a particular seat deliberately submit themselves to the law of the seat and whatever control it exerts. They do this in the interests of certainty. This may be a more parochial vision of arbitration than romantic transnationalism, but I believe it to be more realistic. And he then says it could be interesting here to look at some customer research. And if one drops, again, some 10 lines, in the middle of the line, he starts saying, I question how often the seat of arbitration is fortuitous, particularly under systems like the English, where the place and seat of arbitration can be differentiated. One would expect the seat to be chosen for good legal reasons, not just for hotel convenience or as a good place to dine or party. But this is increasingly understood, appears to be confirmed by a comparison of the Queen Mary International Arbitration Surveys conducted in 2006 and 2015. And he refers to the 2015 survey saying that preferences for seats are predominantly based on users' appraisal of the seat's established formal legal infrastructure, the neutrality and impartiality of the legal system, the national arbitration law and its track record for enforcing agreements to arbitrate and arbitral awards. And Lord Mance agrees that the importance of selecting a suitable seat for an international arbitration cannot be overstated. Now, we've included in the bundles a copy of the 2015 Queen Mary survey. The relevant reference is at page 7256. But we've also included a copy of the 2018 study to similar effect. And if your Lordships could go to electronic bundle 7319. Your Lordship will see the executive summary for the 2018 study, which is the most recent that's available. And in the second column, under the heading, the evolution of seats and institutions, you'll see in the first bullet point, 5 most preferred seats of arbitration being London, Paris, Singapore, Hong Kong, and Geneva. And then in the second point, essentially a repetition of the point made in the 2015 version. Preferences for a seat continue to be primarily determined by its general reputation and recognition, followed by users' perception of its formal legal infrastructure, neutrality and impartiality of its legal rights, national arbitration law, and its track record in enforcing agreements to arbitrate and arbitral awards. And the last point in that bullet, we say, echoes the comments of Lord Hoffman in the Front Coma case in relation to the ability to grant anti-suit injunctions. He said it's generally regarded as an important and valuable weapon in the hands of a court exercising supervisory jurisdiction over the arbitration. And again, to illustrate that this is also not parochial, similar views were expressed by the Chief Justice of Singapore, Sundaresh Menon, in 2018. There's an article by him in the bundles. If I could ask your lordships to turn up the article. It starts electronic bundle 7168, but I'd like to ask your lordships to turn to 7194. The Chief Justice says in paragraph 53, 7194, in his Freshfields lecture, Lord Mance forcefully argued that there has been and always will be a special link between an arbitration and his seat. In his view, decisions of the seat are decisions which the parties must, on the face of it, be taken to have accepted when that seat was chosen, and should in the ordinary case be treated as final and binding. And you will see in paragraph 54, he says, I agree with this, and would argue that the preeminence of the seat court is the logical outworking of orthodox common law principles which I have discussed above, each of which is itself built on sound normative foundations. Lords, the next issue I wanted to turn to are issues 1 and 2, proper law of the arbitration agreement. This is section C of our written case, which starts at page 332 of the electronic bundle. It's common ground that the proper law of an arbitration agreement is to be determined by applying common law choice of law rules, not Rome 1. So it's essentially a 3-stage test, express, implied, or closest and most real connection. The parties approach the application of this test, however, from different directions. Chubb approaches it from the perspective of the main contract. It starts by considering whether there's an express choice of law for the main contract and seeks to argue that this is also an implied choice of law for the arbitration agreement. And it then seeks to extend that to cases in which there is only an implied choice of law for the main contract. We say that's not a sensible starting point. We're concerned with proper law of an arbitration agreement, a separable agreement with a different function and lifespan to that of the main contract, and it's common ground that the law governing the arbitration agreement is not necessarily the same as the law of the main contract. Indeed, it's striking, one might think that that's pretty much the first point Chubb makes in its case at paragraph 3. We say, rather neatly reflecting the fact that arbitration agreements are not just like any other clause in the main contract, ordinarily subject to the same proper law. The starting point is that in relation to arbitration agreements, at least, there is an issue as to whether it is indeed governed by the same law. And given we're concerned with an arbitration agreement we say a sensible place to start is with that agreement. That's what I propose to do. Lords, I propose to deal first with the law before turning to the facts, and to start with those authorities where there's a choice of seat, but no express choice of law for the main contract. We say it's easiest to do that, A, because on our case, that is our case, there is no express choice of law for the main contract, and secondly, because it's easier to see the relevance of choice of law for the main contract after one's seen the effect of choosing the seat. So turning to the situation where there's no express choice of law for the main contract, the basic underlying idea, we say, is simple. By choosing a country in which to arbitrate, parties have created a close connection between the arbitration and that country. And it's reasonable to assume from their choice that they attached some importance to the relevant laws of that country, i.e. to the laws that would be relevant to an arbitration conducted in that country. And it's also reasonable to assume they would want their arbitration package to be governed by that law. In a nutshell, if a party specifies simply London arbitration, as many do, what it would want and expect to get is the sort of arbitration they're used to having, something predictable and consistent. If one turns then to the authorities dealing with this situation, we deal with this in our written case, paragraphs 18 to 24. We say the authorities support the following 5 propositions in relation to a choice of seat. Firstly, a choice of seat is an implied choice of law. In other words, it operates at stage 2 of the common law test, not merely stage 3. Secondly, in the absence of an express choice of law for the main contract, a choice of seat is an implied choice of law for the arbitration agreement. And this is so regardless of whether the proper law of the main contract is determined on the basis of closest and most real connection, or on the basis of implied or clearly demonstrated choice. And as I indicated in my introductory remarks yesterday, that is the outcome in every single English authority to date. Thirdly, a choice of seat may also be an implied choice not merely for the arbitration agreement, but for the main contract. Fourth, the implied choice is capable of being overridden if there are, in Lord Dipwalk's words, compelling indications to the contrary. And fifthly, the implied choice may be overridden in relation to the main contract alone. In other words, the usual implication remains for the arbitration agreement, but may be overridden for the main contract given its discrete commercial subject matter. That last point is one I will come back to. Well, turning to the authorities, I will start with Hamlin and Talisker. I wasn't proposing to deal with Jacobs and Credit Lyonnais, the first authority referred to my learned friend. It's not an arbitration case. What Hamlin and Talisker, your lordships, have in the electronic bundle, starting at page 985. Now, as your lordships know, the contract in this case did not contain an express choice of law for the main contract. However, it was to be entirely performed in Scotland, and it was held that the law of the main contract was therefore Scots law. So we have a main contract governed by Scots law. It also contained an arbitration agreement providing for arbitration by 2 members of the London Corn Exchange or their umpire, and the issue, His Lordship's know, concerned the proper law of the arbitration agreement. And there are 2 points, main points we derive from this authority. The first point is that a choice of London as the seat was treated as a choice of law for the arbitration agreement. In other words, what the parties intended. And this is clear from Lord Herschel's speech. If your Lordships go to his speech, starts at 989, picking it up, if I may, at page 990, in the last 5 lines. He says, where a contract is entered into between parties residing in different places where different systems of law prevail, it is a question, as it appears to me in each case, with reference to what law the parties contracted, and according to what law it was their intention that their rights, either under the whole or any part contract, should be determined. So focusing on intention, he gave his answer at page 991 in the bottom half of the page. He said in the paragraph in the middle, now in the present case, it appears to me the language of the arbitration clause indicates very clearly parties intended that their rights under that clause should be determined according to the laws of England, and he then refers to the arbitration agreement, and 6 lines down says, it seems to me that they have indicated as clearly as is possible their intention that that particular stipulation, which is a part of the contract between them, will be interpreted according to and governed by the law, not of Scotland, but of England, and I'm aware of nothing which stands in the way of the intention of the parties, thus indicated by the contract they entered into, being carried into effect. He then goes on at the bottom of 991 to refer to the fact that if the arbitration agreement had been governed by Scots law, it would have been null and void. That's obviously plainly an additional reason for his conclusion. The speeches of Lord Ashbourne and Lord Shand were to similar effect. Lord Ashbourne, your Lordships will see electronic bundle page 998. In the middle of his speech, picking it up at the start of the line that begins law of Scotland, he then says, having regard, however, to the terms of that clause, I'm led to the conclusion that the parties intended that it should be interpreted by the rules of the laws of England alone. And then he explains why. A contract which provided that disputes should be settled by arbitration by 2 members of the London Corn Exchange or their umpire in the usual way distinctly introduces a reference to well-known laws regulating such arbitrations, and those must be the laws of England. Lord Shand, at page 999, 6 or 7 lines down, says, I think it is to be inferred, that's from the arbitration clause, the pars contractus, that the agreement which it contained for the settlement of disputes which might arise out of the contract was to be interpreted and governed by the laws of England. So, first point, a choice of seat is a choice of law for the arbitration agreement. The second point is that this was the position, despite the fact that the main contract was governed by Scots law. The Court of Session had held that the proper law of the main contract was Scots law, and that this determined the law of the arbitration agreement as well. One can see that from Lord Herschel's judgment. Despite this, the House of Lords held that the arbitration agreement was nevertheless governed by English law. Lord Herschel, as your Lordships have seen, saying he couldn't agree with the Court of Session because you needed to consider whether the parties intended their choice of law for the main contract would apply to the arbitration agreement as well. There's a copy of the decision of the Court of Session in the bundles, as your lordships know, because my learned friend took you to that. I want to show your lordships one passage from Lord Kinnair's judgment. Your lordships could go to page 1153 in the electronic bundle. You will have a copy of the decision of the Court of Session, and picking it up with Lord Kinnair's judgment of 1160, if I may. About two-thirds of the way down, there's a sentence towards the end of a line that reads, "And therefore, were it not for the arbitration clause, I should agree with the Lord Ordinary." It's effectively where the second hole punch is or would be. If your lordships have that, Lord Kinnair says, "And therefore, were it not for the arbitration clause, I should agree with the Lord Ordinary and with your lordships that the contract in question is to be wholly performed in Scotland, and that its validity and effect must be determined by the law of Scotland." And then dropping 4 lines, he says, "The only question we have to consider, therefore, is whether the agreement to submit to arbitration is to be governed by the law of Scotland or England." And then at page 1161, he refers to the arbitration agreement at the top of the page, picking it up about 15 lines down after the end of the quotation of the clause. He says, "I think that imports a reference to a known law and practice regulating the constitution and conduct of such arbitrations, and that can only be the law and practice of England. If that be so, London is the place of performance as well as the place of making the contract. No doubt the arbitrators might come to Scotland if they thought it necessary or expedient to make inquiries in Skye, but that would be a question for their judgment." And then skipping 2 lines, "The material considerations are that the tribunal must be constituted in London. The powers of the arbitrators, their umpire, must be determined and their proceedings must be regulated by the law under which they are living. We have constant experience of questions on which parties to an arbitration find it necessary to appeal to the court, and I see no room for doubt that both parties have been willing to carry out their agreement to submit. If questions of that kind have arisen, they must necessarily have been brought before the English courts and determined according to the laws of England." Now, Lord Kinnair obviously dissented in the Court of Session, but it was his view which ultimately held sway in the House of Lords. And the point that he is making in the passage I just read of 1161 is very similar to the point made by Lord Ashbourne in the House of Lords.
Yes, now, Lord Leggett.
Would you agree that the words "in the usual way" are capable of being interpreted and were by some interpreted as an implied choice of English law for the arbitration agreement?
The words are, we say those words are not critical. Slightly surprising if parties intended their arbitration to be governed otherwise than in the usual way. I'll come on to this in a moment. What we do say is that Hamlin and Talisker has been treated ever since as establishing that a choice of seat is ordinarily an implied choice of law for the arbitration agreement. And that's because of the choice of seat, not because of the particular terms of the arbitration agreement in that case. One modern reference is in Dicey and Morris. If your lordships have electronic bundle 1476, at the bottom of 1476, paragraph 16-019, applicable law in the absence of choice. If there's no express choice of law and no choice of the seat of the arbitration, the applicable law of the main contract be determined in accordance with the principles in the Rome I regulation. The arbitration agreement will be governed by the law so determined. If there's no express choice of the law to govern either the contract as a whole or the arbitration agreement, but the parties have chosen the seat of the arbitration, the contract will frequently but not necessarily be governed by the law of that country on the basis that the choice of the seat is to be regarded as an implied choice of the law governing the contract. There's a similar statement in Chitty on contracts. I'll just give your lordships the reference. It's page 5890. It's the text against footnote 6. Well, a couple of short points in response to my learned friend's submissions on Hamlin and Talisker. My learned friend suggested that the main contract in Hamlin and Talisker was not found to be governed by Scots law by implied choice, but only at stage 3, and he referred to a passage in Lord Watson's speech in support of that proposition. We say that's not a fair reading of the rest of their lordships, nor indeed Lord Kinnear in the Court of Session. We say the analysis in Hamlin and Talisker was the main contract was found to be governed by Scots law as the lex loci solutionis, and that was treated as also an implied choice. My own friend also submitted that Hamlin and Talisker involved an express choice of proper law for the arbitration agreement based on the wording of that agreement. And he did that, as I understand it, to support an argument that a mere choice of seat is insufficient to amount to a choice of law. In other words, Hamlin and Talisker depended entirely on the wording of the arbitration agreement. I've made the submission that that's not how the case has been interpreted subsequently, and we say there's no need for the additional wording. Parties often express their agreement shortly, for example, simply saying London arbitration. They don't need to state that the Arbitration Act applies because it will do so automatically given that the seat is in England and Wales, nor do they need to state the English court will supervise and support the arbitration and will have jurisdiction to grant an anti-suit injunction, because, as one seen from Lord Mance, their agreement to the seat is agreement to the English court doing precisely that. They certainly don't need to state the arbitrators or the English lawyers, which I think is what my learned friend came close to saying at one point, nor in our submission are the words to be decided in the usual way, some magic formula to indicate English law. There's a number of examples in the authorities of anodyne arbitration clauses giving rise to a choice of law as a result of a choice of seat. I'll just list them. Habas, C. d'Armament, that's the Tunisian case. SAIL and Hind Metals, it's electronic bundle 3999 on the right-hand side. C&D, it's electronic bundle page 561. Joshua and Sharma, electronic bundle 1106. The SLS Everest, electronic bundle page 4414. And the Mariana, page 4388. Those are all cases in which a choice of seat on the back of what I've described as an anodyne arbitration agreement has been held to give rise to a choice of law for the arbitration agreement.
Yes, Lord Leggett.
I'm sure coming on, Mr. Dicker, to the underlying reasoning, but all the cases up to and including Tunisienne, insofar as there is reasoning spelt out, it seems to be the assumption that if you choose arbitration in London, the arbitrators will know English law, but you wouldn't expect them to know some, unusual foreign law. that, as Lord Wilberforce was beginning to point out in Tunisian, is not an approach which really is applicable anymore when London has become an international commercial centre.
Well, my lord, the first response to that is in our submission that's not actually the case in relation to Hamlin and Talisker. That's not Lord Kinnear's approach. The passage I read emphasised the connection with English law, not as such familiarity of English arbitrators with English law in relation to the main contract. Similarly, the passage from Lord Ashbourne's speech, shorter but to similar effect. And one needs to bear in mind that in Hamlin and Talisker itself, although the arbitration agreement was governed by English law, the main contract was governed by Scots law, and there's no statement there that what was critical was that Scots law was the same as English law, and therefore the arbitrators could be expected to understand that law. Your Lordship's right, and I'll come on to Lord Wilberforce shortly, that the international aspect of English arbitration became increasingly obvious, and Lord Wilberforce does deal with this, but he makes it plain that the inference which arises despite the international nature of English arbitration, rather than that being the reason for it. Well, can I?
Yes, Lord Sales.
Yes, thank you, Mr. Dicker. I was looking again at the Dicey and Morris. If I could invite you to go back to page 1477, please. And this is the passage that you took us to, I think, to summarise the effect of the authorities that you referred to. And as I'm understanding what is written there, this is addressing situations where there isn't a reference in the main contract to specify what the proper law of the contract is. And in effect, the only clue you've got is a specification of the seat of the arbitration in the arbitration clause. And then the reasoning seems to be that if that's the only clue you've got, you infer back from that what is the implied choice of the law, and it says governing the contract. And it then goes on, in each of these cases, the main contract and the arbitration agreement will be governed by the same law. And what I wanted to ask is, doesn't that have some tendency against your argument, which is to separate out consideration of the proper law of the main contract and consideration of the proper law of the arbitration agreement? Because these cases seem to demonstrate that if you've got a clue in the arbitration agreement taken from the choice of seat, that also leads to an inference as to choice of proper law for the main contract. In other words, on the basis that the main contract and the arbitration agreement are in fact so closely connected that you would expect them to have the same.
And my lord, that is a point dealt with, as you will see from the sea armament case. Going back to one of the propositions I made earlier, the choice of seat does lead to an implied choice of law. We say it's an implied choice of law for the arbitration agreement, and it may also be an implied choice of law for the main agreement as well. It's capable of being rebutted, and it's capable of being rebutted for the main agreement, but not also the arbitration agreement. And
forgive me, I don't think anyone's disputing that you can have separate proper law for the two contracts and that in certain respects they are separate. The point I was putting to you was more, what inference do you draw as to the parties' intention if all you've got is indication of the seat, in other words, an indication as to choice of proper law for the arbitration agreement. And the inference seems to be, according to what Dicey and Morris say, that it's not just an inference as to choice in respect of the arbitration agreement, but by virtue of the connection between arbitration agreement and main agreement, and the inference is choice of law for the main agreement as well. And what I was putting to you is, if by contrast you have a clear indication of choice of law in the main agreement, might it not be said that the same underlying reasoning that one expects the two to be the same then leads to the, if you like, the opposite inference, that since the parties have clearly chosen a proper law for the main agreement, that choice by inference applies also to the arbitration agreement. And
Lord, that's obviously something I will be coming on to and need to deal with. Lord, 2 points. First of all, your Lordship's focusing on a situation where there's an express choice of law. Obviously, at this stage, I'm dealing with a situation where there's no express choice of law for the main contract. There is simply a choice of seat.
Right.
And the submission, as your Lordships know, at this part of the argument is choice of seat is an implied choice of law. I agree, it can be an implied choice of law, not merely for the arbitration agreement, but also for the main contract. Lord, one point we'll come to when one comes to consider choice of law for the main agreement, whether expressed, clearly demonstrated, or implied, is whether there's actually any logic in saying that that choice applies equally to the arbitration agreement. There's been a choice, but the question is that choice intended to apply also to the arbitration agreement? And one interesting feature of the cases is a natural hesitation about holding it does. So, for example, you see a phrase like this policy is governed by New York law, and rather than simply say, well, that means the entire agreement is governed by English law, there's a hesitation. There's perceived to be an ambiguity because of the different nature of an arbitration agreement. Is it actually intended to be governed by New York law? Similarly, when one comes to clearly demonstrated or implied choices, the reasons why a choice of governing law for the main contract may be implied or clearly demonstrated may be perfectly valid for the main contract, but have little or nothing to say about the arbitration agreement. Again, I'll come to this, but clearly demonstrated, the sort of things one is often looking for is a standard form agreement commonly governed by a particular law, course of dealing between the parties. Under Article 4, various connections, all of those may indicate and make good sense in indicating a choice of law for the main agreement. But in our submission says little or nothing about the arbitration agreement because it's commercially distinct, as your Lordship said, in that sense at least separable.
Yes, thank you.
Can I turn next to C. d'Armament, the Tunisian case? Your Lordships have it in the electronic bundles, page 775. Now, as your Lordships know, the issue in this case was slightly different. After Hamlin and Talisker, a line of authority had developed holding that it was an irresistible inference that a choice of seat was a choice of law even for the main contract. We list the authorities in paragraph 19 of our written case and at footnote 19. In C. d'Armament, the House of Lords was concerned with whether the main contract was governed by English law, given the existence of a London arbitration clause, or by French law, and whether any inference was indeed irresistible. And we say the decision is important for 4 reasons. The first is that although the House of Lords held that a choice of seat did not give rise to an irresistible inference of a choice of law for the main contracts, Lordships nevertheless referred to it as giving rise to a strong inference, even in this context. Can I just show your Lordships a few short passages. The first, Lord Reid at 787 of the electronic bundle, it's at letter E. He says, of course, the fact that parties have agreed that arbitration should take place in England is an important factor. In many cases, may be a decisive factor. Although he goes on to say it would, in my view, be highly anomalous if our law required the mere fact that arbitration is to take place in England to be decisive as to the proper law of the contract. But Lord Reid says an important factor. Lord Morris, if your lordships go on to 791, just above letter C, he says, in many cases, it would be reasonable to infer that the parties so agreed. So he rejects just above at B, the idea it's a necessary or irresistible inference. He's saying just above C, there might be such additional agreement or there might not. In many cases, there might be. In many cases, it would be reasonable to infer the parties so agreed. Lord Wilberforce 799, just below letter D, says, unless otherwise constrained, I would regard this clause as a weighty indication, one which may yield to others. And at 802, between C and D, lordships have that. He says, I fully accept that, especially where the parties are of different nationality and there is no other relevant factor, a clause providing for arbitration in a third country is a strong indication, which, because there is no other, may be called conclusive in favour of the proper law of that country. And then Lord Diplock, page 807 of the electronic bundle, at letter H at the bottom, he says, the fact they've expressly chosen to submit their disputes under the contract to a particular arbitral forum of itself give rise to a strong inference they intended that their mutual rights and obligations under that contract should be determined by reference to the domestic law of the country in which the arbitration takes place. Since this is the law with which arbitrators sitting there may be supposed to be most familiar, but it's an inference only. And then at 812, at letter E, he says, I do not wish to throw any doubt upon the proposition that an arbitration clause is generally intended by the parties to operate as a choice of the proper law of the contract, as well as the curial law, and should be so construed unless there are compelling indications to the contract, the other terms of the contract or the surrounding circumstances of the transaction. The mere fact there are other systems of law with which the transaction has a closer connection is not sufficient to rebut the implication. That's obviously...
Yes, Lord Hamblin.
So, Mr. I see that's what they say, but why should that be so? I mean, why should it be a strong indicator of the governing law of the main contract?
Absent any other indication, parties have stipulated that their dispute is to be decided by the English court. It's a short step, we would say, saying that...
English arbitrators, not court.
But so the English court, or equally arbitrators in England, because the arbitration agreement with its seat in England has its gravitational centre in England, because of the connection between the choice of seat, choice of curial law, as of the court under section 67 and 68 in the event that there's an award and it's challenged. That's the reason. Now, in a sense, for my point, whether the strength of the inference, so far as the main contract is concerned, is in a sense less important. What we do say is that if this is the strength of the inference for the main contract, it must on any basis be considerably stronger so far as the arbitration agreement itself is concerned. Now, you can imagine, as in C. Damamont, you have a main contract governed by a foreign law arbitration agreement. Its connection with England, the application of the Arbitration Act 1996, the role of the English court in supervising, supporting that arbitration, we say makes perfect sense to regard the choice of seat as an implied choice of English law for the arbitration agreement.
I'm just focusing on why it's a choice for the main contract. I mean, certainly the reasoning that depends on knowledge of English law would seem to be rather out of date in the context of international arbitration.
And if one goes back to Lord Wilberforce's speech in Company d'Armament, if your lordships have page 799, between letters B and D,
yeah,
this is the point that Lord Wilberforce addresses. He says the selection of a certain place for arbitration and by inference of nationals or residents of that place as arbitrators, an indication the parties intended the law of that place to govern is a sound general rule. It should not be treated as giving rise to a conclusive or irresistible inference, as recent pronouncements appear to suggest. And he goes on to say, one of the reasons commonly given for attributing overwhelming force to the clause arbitrators in London only to be supposed to be conversant with English law, but I venture to think that in commercial matters at the present time this may give insufficient recognition to the international character of the City of London as a commercial centre. So Lord Wilberforce acknowledges my Lord Hamlin's point. He says English arbitration is an international jurisdiction, but nevertheless he goes on to say below letter D, it's still a weighty indication. Even
but that was 50 years ago, and international arbitration has grown greatly since then. And the point he makes there is surely much more forceful now than it was then.
Well, Lord, we say it's still a weighty indication. One can have a debate about precisely how weighty. Obviously, the important point from my perspective is whatever weight it carries in relation to the main contract, when one comes to the arbitration agreement, it must undoubtedly have additional and, we say, considerable force.
But there's no treatment of the arbitration agreement separately in this judgment or in any of the earlier ones, as far as I know, apart from the Hamlin judgment. And if the reasoning is familiarity with English law, that is why it's an implied choice for the contract. If that doesn't work for the main contract, it's not going to work for the arbitration agreement either, is it?
Well, we say not so. We say that in C. Damamont, the issue they were considering was the strength of the inference in connection with the main contract. And Hamlin and Talisker confirms that the two questions are distinct. What the House of Lords in C. Damamont held that in that case the inference wasn't sufficiently strong in relation to the main contract. We say that didn't displace, and there's nothing in the judgment to indicate that that displaced the position in relation to the arbitration agreement. Hamlin and Talisker could still apply. It would still mean the proper law of the arbitration agreement was English law, despite the fact that inference for the main contract had been displaced, because, as Hamlin and Talisker says, that they're two different questions. And they each.
I know they're two different questions, but if the argument that the arbitrator's familiarity with English law it doesn't persuade the court that English law carries the day for the main contract, and so they're going to have to apply French law for the main contract. There's nothing left in that argument to say, oh, well, nevertheless, their familiarity with English law should carry the day for deciding on the scope or validity of the arbitration agreement.
And my Lord, that's why I emphasised in relation to Hamlin and Talisker, Lord Kinnear's judgment in the Court of Session, Lord Ashburn in the House of Lords, not basing it on familiarity simply with English law, but with the connection with the English legal system, and as I said, in our submission, that's how Hamlin and Talisker has been approached, and that's how this general rule has been approached since then. Choice of seat is a choice of law, not simply because the arbitrators are presumed to be familiar with English law and not familiar with any other law, but because of the gravitational connection between an arbitration in London and with English law through the curial law, supervisory role of the court of the seat, and various other points, which I'll come to. But Lord, I'm conscious I was dealing with authorities. I have a section dealing with the rationale for it. Maybe I won't need to cover that at quite such length. I'm obviously also keen to make progress given the limited amount of time I have.
So, thank you.
The point I was just making about the two being different, we do say one can see that being recognised in the C. d'Armament case. So if one goes back to Lord Wilberforce at 799, which we were just looking at, this is the distinction we say he's drawing between E and H. Between E and H, he's referring to Hamlin and Talisker, and he's making the point that if you carefully read it, that decision is a decision on the validity of the arbitration clause and the law governing that clause. Their lordships were most careful in their language to limit their decision as to the applicability of English law to the arbitration clause whose validity was in question, not to exclude the application of Scottish law as the lex loci solutionis to the rest of the contract. And he says, but just below G, the limitations of the opinions is clear. The case ought not to be cited as more than indirect authority on the proper law of the contract as a whole. So we say, distinguishing the two questions, proper law of the arbitration agreement, Hamlin and Talisker, does it necessarily extend to the main contract as well? C. d'Armament says not necessarily, although it's still a weighty factor. The case also deals with the relationship between a choice of seat and a choice of curial law, and it's worth picking up that point whilst we have the case open, because Chubb asserts in its written case that the choice of seat is not a choice even of the curial law. It says that at paragraph 37. It's a slightly barren point because Chubb accepts the effect of choosing a seat is the curial law seat applies automatically, and whether one says that's the result of the party's choice or something that's imposed on them as a result of their choice doesn't matter. But Chubb's assertion is also inconsistent with Lord Diplock in C. d'Armament. If lordships can just go to page 807 of the electronic bundle. He says at letter B, an express choice of forum by the parties to a contract necessarily implies an intention their dispute should be settled in accordance with the procedural law of the selected forum and operates as if it were also an express choice of the curial law of the contract. Well, there are a number of cases since C. d'Armament which have reaffirmed that in the absence of an express choice of law, a choice of seat gives rise to a strong inference. The parties have chosen the law of the seat as the proper law, not merely for the arbitration agreement, but also for the main contract. We list the cases in footnote 21 of our written case, page 334 of the electronic bundles. And just so your lordships can see the list, page 334, SLS Everest, that's Lord Dunning, Marianne Nana, and Lord Justice Ackner, Naviera Amazonica, Lord Justice Carr, who made the point, I'm sure your lordships know, there's no difference as regards an agreement for ICC or ad hoc arbitration in this respect. Sale and Hind Metals, Justice Hobhouse, Comenios, Lord Justice Bingham, and Union Marine and Government of Comoros, as Justice Leggett as he then was. What I do need to deal with two more recent authorities to consider the effect of choice of seat, particularly in relation to arbitration agreements. And the first is the Solamerica case. Your lordships have that in the electronic bundles, page 1130. Lord, if your lordships go to 1142, in paragraph 26, Lord Justice Morbig distinguishes two situations. The first is if the court were concerned with a freestanding agreement to arbitrate in London containing no express choice of proper law. He says, unlikely there would be a sufficient basis for finding an implied choice of proper law. Simply be necessary to seek to identify the system of law with which the agreement has the closest and most real connection. Now, unfortunately, neither Hamlin and Talisker nor C. Darmamont appear to have been cited in Solamerica. And we say that the reference to closest and most real connection there it was made in ignorance of Hamlin and Talisker, and the correct approach is choice of seat is a choice of law at stage 2 rather than simply stage 3. But he goes on at paragraph 26, letter E, to say in those circumstances the significance of the choice of London as the seat of the arbitration would be overwhelming. So in the first case, no express choice of law. He ends up, I might say, in the right place. Choice of seat would be overwhelming. And in our submission, that's plainly correct, although, as I say, something that one gets to by stage 2 rather than stage 3. The second situation he deals with, just below letter E, is where the arbitration agreement forms part of a substantive contract. An express choice of proper law to govern that contract is an important factor to be taken into account. Also, your lordship should note he uses the word express a further 3 times in paragraph 26. So in this second situation, he's dealing with a case in which there is an express choice of law of the main contract. We obviously say that's not this case. What we do say is Solamerica is entirely consistent with the proposition that in the absence of an express choice of law for the main contract, a choice of seat will ordinarily be a choice of law for the arbitration agreement. The only difference one might say between my case and Solamerica is that in our submission, it's a stage 2 point rather than a stage 3 point. And we say that's what one would expect as it enables the entirety of the parties' arbitration package to be governed by the same law. And there is an interesting passage earlier on in Lord Justice Moore-Bigg's judgment that's relevant here. If I could ask your Lordship to go back to 1136. It's paragraph 9. And between E and F, Lord Justice Moore-Bigg says, in Fiona Trust and Holding Corporation, House of Lords re-emphasised both the presumption that parties to a contract who have included an arbitration clause intend that all questions arising out of their relationship should be determined in accordance with their chosen procedure, and the separability of arbitration agreements which enables their intention to be effective. Now, one aspect of the parties' relationship consists of the package of rights and obligations constituted by their arbitration agreement. And we say, consistent with the comment in relation to Fiona Trust, one would expect questions of validity and scope of that agreement to be chosen by their chosen procedure. The third authority is the Habas, Sanayi and V.S. Steele case, decision of my Lord Hamlin, as Miss Justice Hamlin. It's in the electronic bundle starting at 967. And the relevant paragraphs 101 to 103. 101 refers to Sul America and a decision of Mr. Justice Andrew Smith in the Arsenova and Cruz City case, and summarises the guidance provided by those authorities. There's then, we say, an important point in paragraph 102. In relation to point 3, I would add the terms of the arbitration clause may themselves connote an implied choice of law. Recognise they may operate as an implied choice of law for the main contract. In such cases, they must surely equally operate as an implied choice of law for the arbitration agreement. Lord, that, in short, was the point I was seeking to make earlier. Third, paragraph 103, the present case is one there is no express choice of law in the matrix contracts. In such a case, the Sul America decision is clear authority that the applicable law will be that of the country of the seat. Lord, I emphasise it again, but this is the outcome in every single English authority. So for a very long period of time, English courts have reached the conclusion that absent an express choice of law in the main contract, a choice of seat is a choice of law for the arbitration agreement, whether or not it is also a choice of law for the main contract. Now, whether one puts that on the basis of stage 2 or the overwhelming connection under stage 3 in our submission may not matter. We say, strictly speaking, it's stage 2.
Yes, Lord Hamilton.
So the point that's put against you is that it should make no difference whether it's an express choice or an implied choice. It's still a choice. What do you say about that?
Well, again, it's a point I'll deal with at length later, but right. The short answer is that there are two different exercises going on here. If one has an express choice, that's ultimately a question of construction of the language. And it may be that that language is sufficiently clear, unlike words like policy, to indicate that the parties intended the arbitration agreement to be governed by the same law as the main contract. And obviously, if they do so, that's an end of it, because parties can choose what law they want. The clearly demonstrated or implied choice situation is different. My own friend stressed on a number of occasions that it's just as much a choice. And it obviously is. But in our submission, the critical question is choice of what? If the reasons why one holds it's a choice of law for the main contract are relevant to the main contract, they may not also be relevant to the arbitration agreement because different factors apply to that. It's a point I'll come to later. It's a point picked up in various of the commentators. It goes back to the idea that an arbitration agreement is commercially distinct, separable, raises its own issues, and the reasons why it may be appropriate to imply a law for the main contract may not necessarily hold the same weight or indeed any weight when one comes to the arbitration agreement. Well,
Yes, Lord Sayles.
Yes, you say that where there's an express choice made in the matrix agreement as a matter of construction of the express terms, that may cover the arbitration agreement. But there's another case as well, isn't there, that the express choice in the matrix agreement may be clear as to the express terms in relation to that agreement, but one can still draw the inference in ordinary cases, even though it doesn't expressly apply to the arbitration agreement, that by implication, the parties did intend, because they've specified expressly in relation to the main agreement, that it should apply also to the arbitration agreement. What do you say about that intermediate case?
Lord, the response to that is that we then have essentially two implied choices. We have choice of seat, which is an implied choice of law for the arbitration agreement. We have a implied choice for the main agreement, and the question is whether or not that implied choice of the main agreement is sufficient essentially to jump the gap to apply to the arbitration agreement as well. So it's
Sorry, I may not have been clear. In my example, I was saying express choice for the main agreement, not implied choice. But on its terms, it's not clear that that express choice applies in relation to the arbitration agreement. But nonetheless, because the parties have made an express choice in relation to the main agreement, it can be inferred that by implication they intended that same choice to govern in relation to the arbitration agreement.
And my lord, we say one needs to distinguish between the two situations. One, express choice, where the language is such to indicate the parties have intended to cover the arbitration agreement as well. But the second case, as I understand it, your lordship's dealing with, is where it may be because words like this policy is governed by New York law, for example, are used. It's ambiguous. So it's not an express choice. It may be an implied choice for the arbitration agreement. But at that point, we say, well, one has two implied choices, which is the one to govern. And we say that because one's dealing with a commercially distinct, separable agreement for an arbitration agreement, that there's essentially a gap between that and the main contract. It doesn't exist in the same way in relation to most other provisions of contracts. And it's not always possible to jump that gap. And if one's got a conflict between two implied choices, we'd say the natural result is it's the implied choice of seat, because that relates directly to the arbitration agreement.
Yes, thank you.
Lord, I noticed the time. I don't know whether
Yeah. Well, if it's convenient for you, Mr. Dicker, we'll take 5 minutes now. Yes, Mr. Dicker.
I've dealt with the authorities which establish that a choice of seat is ordinarily an implied choice of law for the arbitration agreement, absent an express choice of law for the main contract. I now want to deal with the reasons why we say this is correct as a matter of principle, and there are essentially four. We deal with them in our written case, paragraph 25 and following, page 337 of the electronic bundle, just to identify the reasons. Firstly, there is a necessary overlap between the curial law and the proper law of the arbitration agreement. And this suggests that where the parties have chosen a seat, the same law should govern all aspects of their arbitration package. Secondly, one reason why international businessmen choose London arbitration as a neutral dispute resolution mechanism is to insulate their arrangements from the national law of either party. And it makes no sense, we say, for them to have intended that the validity and scope of that arrangement is nevertheless to be governed by the national law of one of them. Third, this is consistent with the rule that the English court is required to apply when it considers a challenge to the enforcement of the award. And fourthly, even if there is an implied choice of law for the main contract, there's no reason for thinking this was intended to displace the implied choice arising from the Court of Seat, just as in Hamlin and Talisker, the implied choice of Scots law for the main contract didn't displace the implied choice of law for the seat of the arbitration agreement. That's because, as I've submitted, the main contract and the arbitration agreement have distinct commercial functions, and the reasons which may establish an implied choice for one don't necessarily establish an implied choice for the other. There's a gap between the two which has to be bridged, and it may or may not be possible to do so. So expanding on those 4 points, the first reason why we say the emphasis on the choice of seat is correct is because there's an overlap between the curial law and the proper law of the arbitration agreement, and that suggests the law of the two should be the same. And this is the point Lord Justice Popperwell made in paragraph 96 of his judgment. There are a number of aspects to this which we deal with in our written case, paragraphs 26 to 36. Given time constraints, I'm going to have to deal with this fairly shortly. The starting point is that if the seat is London, the provisions of the Arbitration Act obviously apply regardless of the proper law of the arbitration agreement. That's section 2(1) of the Act. And there are a number of provisions of the Act that directly relate to the validity, effect, scope of an arbitration agreement. We identify them in paragraph 27, page 337 of the electronic bundle. One has sections 5 and 6, with formal validity and the definition of an arbitration agreement. Section 7, dealing with the doctrine of separability. Section 12, enforceability of time limits in the arbitration agreement for commencing claims. Sections 28, 1 and 60, agreements as to fees. Section 58, obligation of the parties to honour an award. Section 71(4), validity in some circumstances, Scott and Avery clauses. And 82, subsection 2, the effect of an arbitration agreement on persons claiming through or under a party. All of these provisions are substantive, not procedural, and they all potentially concern the effect of the arbitration agreement and the rights and obligations of the parties. And as Miss Justice Toulson said in the XL insurance case, the Arbitration Act contains various provisions which could not readily be separated, boxes labelled substantive arbitration law or procedural law, because that would be an artificial division. Lords, as your lordships know, some of the provisions are mandatory, others are non-mandatory, apply unless excluded, and are rarely excluded in practice. So our starting point is, as Lord Justice Popperwell said at paragraph 99, one would naturally expect the parties to intend their arbitration package to be governed by one law. One wouldn't have expected them naturally to have intended English law to apply to the matters identified in the Arbitration Act, with other aspects being dealt with by some other law. Chubb has two answers to that I want to address. The first answer they make in paragraph 37 of their written case, and it's that they contend a choice of seat is not a choice of curial law. Chubb says to the extent that such rules are mandatory, they're not chosen by the parties. They are simply the inevitable result of choosing London as the seat. As I understand it, the argument is because they're not chosen, they're not relevant here. Two responses to this. Firstly, Chubb is wrong to say the party's choice of seat is not the choice of curial law. That's the passage I referred your lordships to from Lord Diplock's speech in Company d'Armament, page 807 of the electronic bundle. Perfectly sensible to say that by choosing London as the seat, the parties choose English law as the curial law, and the analogy with the tourist driving to France is, if I'll be forgiven for saying, facile. The reason why a person is driving to France is obviously because they want a holiday in France rather than because they want to be subjected to French traffic laws. It's rather different where one's dealing with a choice of seat. One reason why you choose London as the seat is precisely because you do want the provisions of the Arbitration Act to apply. So describing it as a choice is perfectly valid. Second, even if one says curial law is not a choice, but simply the inevitable result of the decision to choose London as the seat, the point remains. The consequence of choosing London is that the substantive effect of their arbitration agreement is, at least in part, governed by English law, and it therefore makes sense for the entire package to be governed by English law. So this takes one on to the second answer given by Chubb. Chubb seeks to minimize the problem by reducing the amount of overlap between the curial law and the arbitration agreement. Now, obviously, it can't do anything about the mandatory provisions of the Arbitration Act, but its argument is the non-mandatory provisions of the Arbitration Act do not apply if the arbitration agreement is governed by foreign law. And this was obviously the burden of my learned friend, Mr. Landau's submissions. And Chubb says this is the effect of section 4.5, with the result, it says that one is only concerned with the less substantial overlap caused by the mandatory provisions. In other words, there's not much left, Landau would say, to our overlap point. There are a number of detailed answers to Chubb's argument on the authorities we deal with at length in our case at paragraphs 32 to 36. I don't have time to go through those in detail. What I would like to say is as follows. The overall position can be summarized fairly shortly. Section 4.5 is dealing with a situation where the parties have agreed to arbitrate in England and Wales, and thus under the Arbitration Act, but where they have nevertheless expressly agreed to apply another procedural or curial law in respect of some or all of the non-mandatory aspects that would otherwise apply under the Arbitration Act. The situation appears to be a rare one. None of the reported cases appear to have resulted in such a state of affairs. It's also universally treated in the cases as being an undesirable outcome. Can I show your lordship Mr. Justice Savile's judgment in the Union of India and McDonnell case? It's electronic bundle. The judgment starts at 4557. And the passage I want to show your lordships is at 4559 in the right-hand column. It's the last paragraph. What Ms. Justice Savile says there is that it's clear from the authorities cited above, English law does admit of at least the theoretical possibility parties are free to choose to hold their arbitration in one country, but subject to the procedural laws of another. But against this is the undoubted fact that such an agreement is calculated to give rise to great difficulties and complexities. And if one then drops to the next paragraph, as Justice Saville says, such a state of affairs is clearly highly unsatisfactory. Indeed, in Black Clawson, Mr. Justice Mustell, as he then was, described the converse situation, i.e. a foreign arbitration, suggested to be governed by English procedural law, as producing an absurd result. Now, obviously, this is the result that my learned friends are contending for. They're contending for an English seat, but because of the application of foreign law to the arbitration agreement, the non-application of all of the non-mandatory provisions, and in place, whatever the foreign law may or may not provide in relation to those matters. So what my learned friend is contended for is something which Mr. Justice Saville describes as a theoretical possibility, likely to give rise to difficulties and complexities, and what Mr. Justice Mustell referred to in the converse situation as producing an absurd result. What we say, it's clear from the authorities there is no such agreement in the present case, and that even if Chubb were correct, the arbitration agreement is governed by Russian law, this would not be an agreement for the purposes of Section 4.5. Four submissions in relation to my learned friend's submissions on Section 4.5. Firstly, he didn't take your lordships to Section 4.4. I could show your lordships that. It's electronic bundle 1274. So Section 4.4.1274 states, it is immaterial whether or not the law applicable to the parties' agreement is the law of England and Wales, or as the case may be, Northern Ireland. Now, the agreement to which Section 4.4 is referring to is the arbitration agreement. That's what's said in C&D. I'll just give your lordships the reference. It's paragraph 24, page 712 of the electronic bundle. So what Section 4.4 is saying is that it doesn't matter whether the arbitration agreement is governed by English law or foreign law, the non-mandatory provisions still apply unless excluded. On my learned friend's case, however, by entering into an arbitration agreement governed by foreign law, you're automatically excluding all non-mandatory provisions that relate to the arbitration agreement. We say that would be inconsistent with Section 4.4. Section 4.4 shows that Section 4.5 is concerned with the choice of foreign curial law, not simply with and doesn't permit simply an arbitration agreement governed by foreign law to come within Section 4.5. My own friend suggested the commentators favour Chubb's position on this point. In fact, we submit the weight of the commentary, which is cited at footnote 39 of our written case, says the opposite. It includes Russell on arbitration, that's electronic bundle 6442, and also Mustell and Boyd at 6408. So that's the first point. The second point is my lone friend took your lordships to Lord Staines's speech in the Lesotho Highlands case. And he suggested that what Lord Staines was saying was that there was no evidence in that case the law of Lesotho made any provision in respect of any pre-award interest. Can I show your lordships, or remind your lordships of the relevant paragraph? It's page 1018 in the electronic bundle. and it's paragraph 37. And if we just go through this, Ms. Justice Morrison appeared to take the view that the law of Lesotho, as the law applicable to the construction contract, may be relevant. This presumably is on the basis that it constitutes an agreement to the country under section 49. And then he says, ignoring for the moment the fact that one does not know what the law of Lesotho is, this view comes up against the difficulty that only an agreement in writing as defined in the Act can qualify as an agreement to the contrary under section 49. This is no mere technicality. By introducing some formality with respect to all agreements, the possibility of subsequent disputes, e.g. at the enforcement stage, is greatly diminished. The law of Lesotho is not an agreement to the contrary in writing. Now, we say one thing is plain from that paragraph. It is that Lord Steyne was not saying simply that there is no agreement because there's no evidence about the law of Lesotho. He's saying leave that aside. There is still not an agreement that satisfies section 4.5. Lord, as it happens, there was in fact material indicating that the law of Lesotho was different in relation to interest. One can see that from the judgments of Ms. Justice Morrison and the Court of Appeal. I won't turn them up, but if I can give your lordships the reference, it's page 3440 for Ms. Justice Morrison and 3452, 3456 and 3459 from Lord Justice Brooks' judgment. But the short point is we say neither my learned friend's submission nor, with respect to the article from Mr. Vida, is a satisfactory explanation of paragraph 37 of Lord Steyne's speech. The third point is what we refer to in our written case as the problem of conflicting choices. If one goes back to the arbitration agreement, the Arbitration Act, Electronic Bundle 1274, Section 4, 4.3 provides the parties may make such arrangements by agreeing to the application of institutional rules or providing any other means by which a matter may be decided. Now, one point we made in our written case was imagine the following situation. The parties have agreed the application of institutional rules. Assume my learned friend is right. You have an arbitration agreement governed by foreign law, and the effect of that is necessarily to disapply all of the non-mandatory provisions. Okay, what then happens? What if there is a conflict between the institutional rules that you have chosen and the effect of the foreign law that you have said governs your arbitration agreement? Which is to govern? It's a point we raised. It wasn't a point that, as far as I could see, my learned friend sought to answer. The fourth and final point is my learned friend didn't really deal with what we say would be the far-reaching and remarkable consequences were Chubb's construction of section 4.5 to be correct. We deal with this in some detail in our written case, and I don't propose to go through it at length, but just to emphasize two examples. On Chubb's approach, arbitration agreements may be invalid merely because the main contract is invalid. That's because section 7 of my learned friend's case is excluded because the arbitration agreement is governed by foreign law. Precisely what happened in the national Iranian case that my learned friends criticize. In that case, a party to a London arbitration agreement sought to attack its validity on the ground that the main contract was invalid under Iranian law and that Iranian law does not recognize the doctrine of separability. We say a party who has specified London arbitration wants an arbitration in London, he would not contemplate a situation in which, because his arbitration agreement was held to have been governed by foreign law, because that foreign law didn't have a similar regime to Section 7, the arbitration agreement was invalid, and therefore he was forced to litigate in the foreign jurisdiction. That's one consequence of my learned friend's submissions. Second, we say equally striking consequence is that a party to a London arbitration agreement may be able to challenge the award in a foreign court, because in his case, Section 58 has been excluded. Well, my own friend described our submissions in this respect as a submission in terrorem. Whether or not one would necessarily apply that label, we would say that these consequences are indeed striking. A party who specifies London arbitration wants an arbitration, no doubt the sort of arbitration that he is familiar with. The idea that he'll end up with an arbitration where the arbitration agreement is invalid and he has to litigate in the foreign jurisdiction would be anathema to him. The idea that having got an arbitration award, the other party can then challenge it in a foreign jurisdiction would equally be anathema. Well, we say there is an overlap, and my learned friend's submissions seek to minimize the effect of overlap are incorrect. Now, even if my learned friend is right, the point still remains that there's nothing they can do about the mandatory provisions of the Arbitration Act. They apply regardless, and obviously to that extent at least, there is still an overlap. Well, so that's the first reason why we say choice of seat as a choice of law makes sense as a matter of principle. The second reason concerns the significance of neutrality. One reason why foreign businessmen choose London as the seat is because they want their disputes to be resolved by a neutral forum, to insulate themselves from national law and national legal systems of either party. And we say it just doesn't make commercial sense for a party to say, I want to resolve any disputes by London arbitration, subject to the supervision and support of the English courts, but allow the scope and effect of my arbitration agreement to be determined by foreign law, still less by foreign courts. There's a number of authorities that emphasize the importance of neutrality in the party's choice of seat. Again, if your lordships will forgive me, just give you three references. The first is C. Darnawall. It's Lord Wilberforce, page 599D. It's the electronic bundle at 802. He says choice of a London seat is strong indication that English law applies where the parties are of different nationality. The Egon Ohlendorf and Liberia Corporation decision, this was won by Mr. Justice Mance, as he then was. It's page 2890 of the electronic bundle, page 69, right-hand side of the print. And more recently, Kapatsky and PJSC Kernafter, decision of Mr. Justice Butcher, electronic bundle 2404, paragraph 70, subparagraph 1 of his judgment. Obviously, foreign parties who choose London arbitration do so in part because they want to avoid foreign law and foreign court systems. Chubb's approach, we say, doesn't make commercial sense. Parties who choose London arbitration would at the same time be saying that what they agreed would depend on foreign law. They may, for example, be used to the idea that under English law, an arbitration agreement will cover all disputes in accordance with the Fiona Trust. The foreign law may have a different approach. The point is this: to know what they were agreeing to, the parties would therefore need to analyse the effect of combining the Arbitration Act and the relevant foreign law. What does the foreign law say? and how does it interact with the arbitration agreement? And it necessarily follows that the effect of the arbitration agreement could differ significantly from case to case, depending on what foreign law applied and what it said. So one would necessarily end up in a position where a choice of London arbitration would inevitably no longer be clear, predictable, and consistent, and indeed wouldn't be capable of being so. In our submission, businessmen should not expect to have to engage in the sort of conflicts of laws and comparative law analysis that this would necessitate. Still less would they intend the question of foreign law would need to be decided by the foreign court that they had tried so hard to avoid. So that's the second reason. In response, my own friend appeared to suggest that neutrality is a relevant consideration for determining proper law of the arbitration agreement, only if the main contract is also a neutral law. As I understood his submission, it was that, well, if the parties are happy to choose governing law for the main contract, which is not neutral, then they're obviously happy with laws which are not neutral. With the greatest respect, we say that's a non sequitur. There's no reason why the parties cannot agree that their dispute resolution arrangements are to be neutral, even if, for one reason or another, the substantive rights and obligations are not. An example of this is the Bermuda form. In C&D, Lord Justice Longmore explained as one of its purposes is precisely to provide for the application of New York law, but London arbitration. Lord, can I show your lordship that in C&D? It's 735 of the Lord, I'm sorry, it's at 726, if your lordship could go. It's the start of Lord Justice Longmore's judgment. It says, halfway down paragraph 1, the striking feature of the form, this is the Bermuda form, is that it requires the parties to arbitrate in London, provides for the proper law of the insurance contract with the internal laws of New York. No doubt this represents a balancing of the conflicting interests of the insured on the one hand and liability insurers on the other, and explains the reasons for that. Lord, the third reason why we say the emphasis on the choice of seat is right is because this is consistent with Article 51A of the New York Convention and Section 103(2)B of the Arbitration Act. And I think at one stage, Mr. Bailey appeared to be accepting in his submissions that this was a good reason why a default rule of choice of seat was a sensible one. We deal with this again in our written case, paragraphs 39, 41. The starting point is section 103(2)B, which your lordships have at page 1333. So 103 subsection 2, page 1333 of the electronic bundle, recognition or enforcement of the award may be refused if the person against whom it is invoked proves, and then B, arbitration agreement was not valid under the law to which the parties subjected it, or failing any indication thereon, under the law of the country where the award was made. And as your lordships know, that codifies Article 5.1a of the New York Convention, and your lordships will see text of that at 1355 of the electronic bundle. Article 5.1, recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought proof that A, the parties to the agreement referred to in Article 2 were, under the law applicable to them, under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, failing any indication thereon under the law of the contract, under the law of the country, where the award was made. Now, obviously, for the purposes of this part of our argument, we're assuming there is no express choice of law for the main contract. In other words, there's no indication using the word in Article 5.1a. The result is that in these circumstances, recognition and enforcement can only be refused if the arbitration agreement is invalid under the law of the country where the award was made. And the reference to where the award was made is obviously a reference to the seat. Now, Section 103(2)b obviously doesn't apply in the present case, because it only applies to an award made under an arbitration agreement with a foreign seat. But it does express the default choice of law rule set out in the New York Convention. And where it does apply, the English court may need to determine the proper law of the arbitration agreement, and to do that, it would need to apply the choice of law rule in Section 103(2)b. The point is, there's no reason.
Ms. Dicker, just one question. Under A, the parties have subjected it to a particular law. Is that express choice or express and implied choice?
Lord, that's express.
Yes, Lord Legate.
Right, I think I've tried to find this, but most of the commentaries seem to suggest it includes implied. Although they refer to various French or Swiss authorities for that.
Lord, I have, if I can come back with a definitive answer on that, perhaps. Lord, the point we're making is there is no reason why the choice of law rule should be different if the seat is in England rather than being a foreign seat. Absent an express choice of law for the main contract, the proper law of the arbitration agreement should therefore be the law of the seat. Lord, I'm told by a message from my left that if your lordship look at footnote 63 of our case, that may have an answer to that point. So the submission I'm making here is essentially there is a default rule in the New York Convention. That is reflected in Section 103(2)b. There's no sensible reason why a similar default rule shouldn't apply also in our situation. The starting point is that questions of validity are dependent on law of the seat, failing any indication to the contrary. Now, Lord, I'll deal in due course with the phrase failing any indication, and in particular whether an express choice of law for the main contract is an indication to the contrary within Article 5.1a. But as your lordships will see, the weight of commentary indicates that it's not. In other words, what is required as an indication within 5.1a is not merely an express choice of law for the main contract, but an express choice of law for the arbitration agreement. In other words, an express choice of law for the main contract, which might give rise to an implied choice of law for the arbitration agreement. The context of the MYC isn't enough to enable the gap to be bridged. The fourth reason why we say the emphasis on choice of seat is right as a matter of principle concerns what we call the absence of sufficient connection between the main contract and the arbitration agreement in a situation like this. Now, the fourth reason then is because if one looks at this from the other end, we say there's no substantial connection between the proper law of the main contract and the arbitration agreement. Obviously, I'm dealing with a situation in which there is an express choice of law for the main agreement at the moment, and no reason to think the proper law of the main contract was intended to displace the implied choice of law for the arbitration agreement that arises from the choice of seat. Now, if there's no express choice of law for the main contract, the proper law of the main contract under Rome law will be determined on the basis that it's either clearly demonstrated under Article 3 or determined in accordance with Article 4. And I need to deal with both possibilities. So starting with Article 4, as we understand it, Chubb accepts that if the proper law of the main contract is determined by Article 4, the proper law of the arbitration agreement will be the law of the seat. The arguments it makes in its written case are limited to situations in which there is an express or clearly demonstrated choice of law for the main contract. It's only in those situations that it suggests that the proper law of the main contract may be capable of jumping the gap. And we say that acceptance is inevitable. It's certainly the outcome, as I said, of every single English decision, but we also submit it's correct as a matter of principle. In this situation, the parties only made one choice, their choice of seat, which is a choice of law for the arbitration agreement. And that choice is not displaced by the law that's found to be applicable to the main contract under Article 4. And one can see that if one looks at the factors which are relevant under Article 4 of Rome 1, the Lordships could go to the electronic bundle at 1346. So if one looks, for example, at Article 4.1b, Article 4.1, to the extent that the law applicable to the contract has not been chosen in accordance with Article 3, the law governing the contract shall be determined as follows. B, contract for the provision of services be governed by the law of the country where the service provider has his habitual residence. Now, obviously, the services that are being referred to there are the services that are being provided under the main agreement. Now, 4.1 may be a sensible choice of law rule in relation to the main agreement, but it obviously makes no sense as a choice of law rule in relation to the arbitration agreement for the simple reason that services being provided in the arbitration agreement are different from those in the main contract. Well, if one then turns to clearly demonstrated under Article 3, we say the position is no different if the proper law of the main contract is clearly demonstrated under Article 3 rather than determined on the basis of Article 4. First, the various reasons that I've outlined for treating a choice of seat as a choice of law for the arbitration agreement are obviously unaffected. So one has the overlap with the curial law, desire for neutrality, consistency with the choice of law rule in Article 5.1a of the New Convention. None of these cease to apply simply because the proper law of the main agreement is clearly demonstrated. Secondly, the arbitration agreement still has its closest, most real connection with the law of the seat, not the main contract law. And we say there's an inherent contradiction in accepting, as Chubb does, that the arbitration agreement has its closest connection with the law of the seat, in other words, at stage 3, but also asserting that the party's implied choice, the arbitration agreement, is more likely to have been the main contract law. And the reason for that is this: the justification for the imputed choice of law at stage 3 is that this is the law that the parties would have chosen had they thought about it. And it's been said that the rationale for stage 3 is therefore also the intention of the parties, albeit indirectly. Again, just so your lordships have the reference, that's Vesta and Butcher. It's electronic bundle 3022, page 504, A to B. So the common law therefore already recognises, and my learned friends do not challenge this, that the choice that businessmen are likely to make for the arbitration agreement, if they think about it, is the law of the seat. And we say that suggests it should apply at stage 2 as well. The third point in relation to Article 3 is one I think I've outlined already. We say the exercise of deciding if a choice of law is clearly demonstrated for the main contract may say little or nothing about the proper law of the arbitration agreement. You are concerned with two distinct and potentially different things. The parties may have a clearly demonstrated choice of law for the main contract. It doesn't necessarily follow that they have also clearly demonstrated the same intention to apply to the arbitration agreement. I made the point that my learned friend emphasised the fact that there's a choice in both cases. The point we stress is one needs to identify what the choice is of. And where one comes to article clearly demonstrated under Article 3, there is a question of whether or not it's clearly demonstrated solely for the main contract or also for the arbitration agreement. And these 3 points, we say, illustrate a fundamental flaw in Chubb's argument. One comes back to the point there is, on any basis, an important commercial distinction between the provisions of the main contract and an arbitration agreement. And just one reference to that. There are many in the commentaries. It's from Van den Berg. Your lordships will have it in the electronic bundle at 6584. Lords, I'm sorry, I think I may have a... Well, I haven't got a bad reference. I couldn't find the passage I was looking for. Lord, on 6584, first full paragraph, Mr. Vandenberg starts by saying the problem stems from the wording of Article 5.1a. Subsidiary conflict rule applies failing any indication on the law to which the parties have subjected the arbitration agreement. Submitted that despite this somewhat ambiguous wording, the second opinion represents the better view. Now, your lordships will see above, and I'll show you this in due course, that the second view is that you need an express choice of law for the arbitration agreement itself. Then he goes on to say the main contract and the arbitral clause have different objects. The main contract concerns the relationship between the parties as to the substance. Arbitral clause is concerned with the procedure for settling disputes arising out of the main contract. And he goes on to say, if the parties provide a general choice of law clause, they intend to give a directive to the arbitrator as to which law he has to apply to the substance. Distinction between substance and procedure would then preclude the directive given to the arbitrator would also be an indication of a choice of the law governing the arbitration. It would seem, therefore, that the latter can be achieved only by a distinct express agreement. So we say there is a distinction between arbitration agreements and the main contract, and it's reflected in a number of things. Firstly, it's reflected in the oft repeated statement that the proper law of an arbitration agreement and the main contract may be different. I made the point about the prominence of this point in Chubb's written case. It's the first sentence of their first substantive paragraph. But the prominence of this point in our submission reflects the fact the main contract and the arbitration agreement have a different purpose. It's not a prominence one sees in relation to any other normal provision of the main agreement. Secondly, it's reflected in the doctrine of separability under Section 7. Now, it's important to be clear what our submission here is. Our submission is not that the doctrine of separability under Section 7 applies in relation to law. We accept that's not its purpose. But Section 7 is undoubtedly an illustration or manifestation of the fact that arbitration agreements have a different object, one consequence of which is that they need to be valid even if the main contract is invalid. They don't simply stand or fall, nor are they necessarily to be dealt with in the same way as every other provision of the main contract. Thirdly, it's also reflected in the fact that arbitration agreements are excluded from the scope of Rome I, and by the fact that proper law of an arbitration agreement is governed by the common law choice of rules instead. So arbitration agreements are distinct aspects of a contract, and that distinction is reflected undoubtedly in the three aspects I've mentioned. Now, I've referred to the gap, therefore, between the arbitration agreement and the rest of the main contract, and this idea that it needs to be jumped. I've dealt with Hamlin and Talisker and the fact that a choice of seat may be a choice of law for the arbitration agreement, not necessarily also for the main contract. Obviously, the logic goes also in the other direction. Choice of law for the main contract may be clearly demonstrated under Article 3 or determined under Article 4, but that may say little or nothing about the arbitration agreement. And this is a point made in a number of the commentators. Can I show you one? Fouchard, Gaillard, Goldman. It's electronic bundle 6057. There's a heading on 6057, if lordships have that, the arbitration agreement and the main contract. The passage I want is in the long paragraph, starts about halfway down, and it's about 15 lines from the end of that paragraph. It begins, however, where these two connecting factors diverge, particularly where the chosen seat of the arbitration is neutral with respect to parties, it is more difficult to accept that the law governing the arbitration agreement should always be determined by reference to the law governing the main contract, and not that of the seat of the arbitration. This is because the law governing the main contract will generally have been chosen for reasons other than those on which the choice of law governing the arbitration agreement is based. It's not to say the connecting factor consisting of the seat of the arbitration alone is to be automatically preferred, only that in such circumstances it will certainly counterbalance the law governing the merits of the dispute. So that's why we distinguish between a case in which the language of the agreement as a pure matter of natural language construction undoubtedly extends to the arbitration agreement on the one hand, and a situation whether under Article 4 or Article 3, you're trying to work out what the choice of law should be for the main contract. Our submission is maybe perfectly sensible and valid analysis for the purposes of the main contract. Doesn't necessarily follow that it's also a choice for the arbitration agreement. Now, Chubb makes 2 points to try and establish the necessary jump over the gap from the main contract to the arbitration agreement. Neither in our submission have any force. The first point they make is in paragraph 13 of their written case. What they say is an arbitration agreement forms part of the main contract. That is, of course, correct, and in our submission doesn't take one very far. If one turns up Chubb's written case, just has a look at what they say in paragraph 13. It's at page 277 of the electronic bundle. So they say in 17, page 277, an arbitration agreement forms part of the main contract in which it is incorporated, is concluded at the same time and in the same circumstances. The first reference, interestingly, they give is to Hamlin and Talisker. And they refer to Lord Herschel saying that it's as much a part of the contract as any other clause. But obviously Hamlin and Talisker was a case in which the proper law of the arbitration agreement was found to be different from that of the main contract. The various formulations that Chubb refers to, we say, are also interesting. So they refer to a clause collateral to the main contract in which it is incorporated. That's Lord Diplock from the Powell-Wilson case. And they also refer to an agreement inside an agreement. That's Mr. Justice Saville from the Union of India cases. In our submission, formulations like this illustrate actually that arbitration agreements are not just like any other provision of the main contract. You don't normally describe any ordinary clause in the main contract in this way. You don't describe it as a clause collateral to the main contract or an agreement inside an agreement. These formulations, rather than cementing the arbitration agreement within the main contract, illustrate that it is qualitatively different from other provisions of the main agreement. The second point Chubb makes is to make various assertions as to what it is realistic to suppose. And it does this in paragraph 15 of its written case, page 278. And it's these assertions that it uses to try and find the bridge to overcome the distinction between the main contract and the arbitration agreement. In our submission, these assertions are almost entirely wrong, or at least unsubstantiated. The first assertion is that businessmen are likely to proceed on the assumption that all substantive obligations contained in their contract will be governed by the same system of law. That's paragraph 15.1. it's not clear what the basis is for this. It's obviously contrary to a substantial number of authorities, which have concluded in those cases at least that they're different. It ignores the fact that aspects of the parties' arbitration agreement are going to be governed by a different law in any event, given the overlap with the curial law. So the choice isn't simply between one law and two. There are already two laws, and the question is which of those two laws do the parties intend their arbitration agreement to be governed by? And we say they're more likely to assume that their arbitration agreement will be governed by one law, in other words, by the same law as the curial law. The second assertion that Chubb makes is that there's no obvious reason why the parties should want the scope of their agreement to arbitrate be governed by a different system of law from the rest of their contract. And we say, in fact, it's perfectly understandable. The parties may want their main contract governed by one law, want their dispute resolution mechanism to be governed by a neutral law and determined by a neutral court. Take an extreme case in which their arbitration agreement is invalid under the law of the main contract. It doesn't make sense to say, I would like to arbitrate, but I will agree a law which promptly invalidates the agreement I have just made. The third assertion that Chubb makes is if the parties wanted the proper law of their arbitration agreement to be different, they would say so. But this simply assumes what Chubb is seeking to establish. It assumes that the law of the main contract will apply, and if the parties don't want it to apply, they have to say so expressly. In our submission, it's just as justified to say they assumed their arbitration package would be governed by the law of the seat, so they didn't need to say anything. In other words, all they were doing was saying, London arbitration, I expect to get what I always get whenever I have an arbitration in London. I expect to have the English court supervising, supporting when it does. I expect to have the standard principles applied in English cases to apply. I expect my agreement to be valid. I expect my award not to be open to challenge in another jurisdiction. It's a package the parties are agreeing to. In our submission, the idea that in agreeing to this package, they are at the same time permitting elements of that to be dictated not by English law, but by foreign law, which may produce a completely different outcome, uncommercial in many respects, simply doesn't make commercial sense. Lord Burrows asked a question yesterday that I gave a short answer to, and it concerned the position in relation to exclusive jurisdiction clauses. And just dealing briefly with that, a choice of forum, whether a court or a seat of arbitration, ordinarily gives rise to an inference that the dispute resolution agreement and the main contract are both governed by that law. In the Commonos, Lord Justice Bingham applied C. Darmamol to a jurisdiction agreement. That's Electronic Bundle 3187. And the point is made by Mr. Lewison in his book, paragraph 18.13, and just to give your lordships the reference, Electronic Bundle 6305. We do say the inference is, however, stronger in relation to arbitration agreements and exclusive jurisdiction clauses, because some part of the arbitration agreement will in any event be governed by the law of the forum because of the overlap with curial law. And that feature of arbitration is obviously not applicable also to exclusive jurisdiction clauses. There was one connected point in this, Lord, I'm sorry.
Sorry, can I just be clear then what you were saying? So the proposition I had in mind, I'm not sure I expressed it as clearly as I should have done, is the situation where one's got an exclusive jurisdiction clause, let's say, whereby English law is the exclusive jurisdiction, in a contract that is otherwise indisputably the proper law of which, let's say, is Russian law. The question I'm seeking an answer to is, what is the proper law of the exclusive jurisdiction clause? Am I to understand what you've just said, that the proper law would be regarded as England, of the jurisdiction clause would be English in that situation? Is that what you're suggesting?
Lord, and yes, that is what we're suggesting, and we're suggesting for similar reasons. So take again an extreme case in which the parties have a main contract governed by foreign law. They've chosen England as their exclusive jurisdiction, so it necessarily follows they do not want to litigate in the foreign jurisdiction. Now, assume that the English jurisdiction clause is, of course, valid under English law, but is invalid under the foreign law. If the English exclusive jurisdiction clause is not governed by English law, then there runs into an immediate problem. You apply foreign law to it, it's invalid, and the agreement which they made to litigate in England and not agree to litigate in a foreign jurisdiction has turned out to be ineffective. Now, again, it's a matter ultimately of instruction, but we say there's no reason, although I accept the reasons aren't necessarily as strong in the context of an exclusive jurisdiction clause, why the same sort of analysis should be undertaken in that context as it is undertaken in the context of an arbitration agreement.
Thank you. Let's assume, if I may just come back, let's assume that the issue is not as to the validity of the exclusive jurisdiction clause, but as to its interpretation.
Lord, again, a similar point. If one goes to House of Lords in Fiona Trust, the House of Lords in Fiona Trust said it's a matter of commercial common sense that parties want one-stop adjudication. Now, my own friend described that, I think, in his written case as parochial. It's not expressed as parochial by the House of Lords in Fiona Trust. It's expressed as a matter of commercial common sense. Lord Hoffman refers to Germany taking the same approach. Lord Hope refers to it being applied elsewhere. So again, if you say, I want the English courts to determine my disputes, here's an exclusive jurisdiction clause to enable them to do so. If you then apply foreign law to the interpretation of that clause, you may end up with a situation in which actually all of their disputes are not determined in England, because as a matter of foreign law, only certain kinds of dispute are subject to the exclusive jurisdiction clause. Again, we say if a party wants to have their disputes determined in England as a matter of commercial common sense, that's what they want, and they would intend English law to apply because that's necessary to ensure that they get a sort of package of dispute resolution mechanism that they're intending to have and which they may well be used to having. Lord, I hope that helps.
Thank you very much.
I noticed the time. Can I just make one further short point? I'm sure your lordships are familiar with Article 25 of the Brussels I recast regulation. I say that because I'm afraid we don't have it in the bundles. But it provides that if the parties, regardless of domicile, have agreed that a court or courts of a member state are to have jurisdiction, that court or those courts shall have jurisdiction unless the agreement is null and void as to its substantive validity under the law of that member state. Now, this is obviously under a regulation. It's not a common law matter. but there's a similar point here, which is if you have a jurisdiction clause in favour of one jurisdiction, that agreement ought to function unless that agreement is null and void as to its substantive validity under the law of that member state, not the law that governs the main agreement, but the law of the member state identified as the state to decide the dispute. I'm conscious we don't have that in the bundle. We can obviously provide it to your lordships. I wonder if that would be a convenient moment.
Yes, very well. We'll sit again at 2 o'clock.